So, you are staring at an MBE practice question that hinges on res ipsa loquitur and your mind goes blank. Or you are in a 1L exam and you can't remember whether it's a stare decisis or res judicata that applies. Legal maxims, those short latent phrases that pack an entire legal principle into a few words, show up constantly on the bar exam, in 1L cold calls and in real case laws. Most students just try to memorize them and forget them a week later. Today we are covering the 20 most important legal maxims you need to know. For each one, we'll break down the exact meaning, walk through a real famous case where it was applied, and give you a quick trick to lock into your memory for the exam day. And this is a long one, so stick with it. Every legal maxim here is genuinely high yield, spanning torts, contracts, criminal law, constitutional law, and civil procedure. So let's get started. So, maxim number one is stare decisis, meaning to stand by things decided. Courts should generally follow the precedent set by the prior decisions on the same legal issue, so the law stays consistent and predictable. It's the backbone of the common law system. The best illustration of this is Brown versus Board of Education. The Supreme Court overturned its own 58-year-old precedent, Plessy versus Ferguson, which had upheld separate but equal. It shows stare decisis is the strong default, but the court can depart from it where a precedent is fundamentally unjust. Here's an exam trick to remember it. Precedent binds courts, but even the Supreme Court can break from it for a compelling reason, exactly like Brown overruling Plessy. Maxim second is actus non fecit reum nisi mens et rea, meaning an act doesn't make one guilty unless the mind is also guilty. Most crimes require two elements, actus reus, a guilty act, and mens rea, a guilty mind. Proving the act alone usually isn't enough for a conviction. The best illustration of this is Morissette versus United States. A man took spent shell casings from a bombing range, genuinely believing they were abundant. The Supreme Court held that criminal intent is presumed to be required even when a statute is silent about it. Here's an exam trick to remember it. No crime without both the act and the intent. Morissette confirms mens rea is read into a statute even when Congress didn't say so. Now, maxim 3 is Respondeat superior, meaning let the master answer. An employer can be held vicariously liable for an employee's tortious acts as long as those acts happened within the scope of employment. The best illustration of this is Ira S. Bushy and Sons versus United States. A drunk Coast Guard sailor returning from shore flooded a private dry dock by turning wheels he shouldn't have touched. The court held the government liable. The risk was a foreseeable incident of the employment relationship. And here's an example to remember it. Employer pays for the employee's acts, but only within the scope of employment. Judge Friendly's foreseeability test from the Bushy is the key. Now moving on to maxim 4, res ipsa loquitur, meaning the thing speaks for itself. In certain situations, an accident is so obviously the result of negligence that the plaintiff doesn't need to prove exactly how it happened. The facts speak for themselves. The best illustration of this is Ibarra versus Spangard. A patient woke up from surgery with a new shoulder injury unrelated to the procedure, since he was unconscious and couldn't say which of several doctors caused it. The court allowed res ipsa loquitur against all of them. And here's your exam trick to remember it. Can't pinpoint exactly how the negligence happened, but the facts obviously scream negligence. That's res ipsa loquitur. Think Ibarra's unconscious patient. Maxim 5th is volenti non fit injuria, meaning to a willing person, no injury is done. If a plaintiff knowingly and voluntarily encounters a risk, they generally can't later recover damages for harm that results from the exact risk, known in the US as assumption of risk. The best illustration of this is Murphy versus Steeplechase Amusement Company. A rider was injured on an amusement park ride called the Flopper. Judge Cardozo famously wrote, "The timorous may stay at home. The danger was open and obvious, and the rider accepted it by choosing to ride." Here's an exam trick to remember it. The timorous may stay at home. Cardozo's famous line, know the risk, choose it anyway, and you generally can't sue over it. Coming on to Maxim 6, that is caveat emptor, meaning let the buyer beware. Historically, buyers were responsible for inspecting goods themselves before purchase. Sellers had no general duty to disclose every defect. The best illustration of this is statutory doctrine, implied warranty of merchantability. The old caveat emptor rule that has been heavily narrowed by the Uniform Commercial Code, which now implies warranties into most sales of goods, plus the Magnuson-Moss Warranty Act for consumer products. Here's an exam trick to remember it. Old rule, buyer beware. Modern reality, UCC implied warranties now do a lot of the buyers protecting for them. Maxim 7 is res judicata, meaning a matter already judged. Once a final judgment is entered on the merits, the same parties can't relitigate the same claim in a new lawsuit, also called claim preclusion. The best illustration of this is Federated Department Torts Inc. versus Moiety. Plaintiffs tried to avoid preclusion by arguing their earlier dismissed case was wrongly decided. The Supreme Court held res judicata applies even to an erroneous judgment. Finality matters more than re-arguing old losses. Here's your exam trick to remember it. Once decided, it stays decided. Even a judgment you think was wrong still has preclusive effect, per moiety. Maxim 8 states habeas corpus, meaning you shall have the body, a writ that lets a detained person challenge the legality of their detention before a court, one of the oldest protections against unlawful imprisonment. The best illustration of this is Boumediene versus Bush. The Supreme Court held that detainees at Guantanamo Bay have a constitutional right to habeas corpus, even though the base is outside sovereign US territory. Congress can't simply legislate the right away. Here is an exam trick to remember it. Habeas corpus means bring the person to court and justify the detention. Boumediene shows it can reach even Guantanamo. Maxim 8 states ex post facto, meaning after the fact. Laws that retroactively criminalizes conduct or increase punishment for an act already committed are unconstitutional under Article 1 of the Constitution. And the best illustration of this is Calder versus Bull, one of the earliest Supreme Court cases where Justice Chase laid out 4 categories of laws that count as unconstitutional ex post facto laws, still cited today. And here's your exam trick to remember it. Can't punish someone under a law that didn't exist when they acted. Calder versus Bull is the original blueprint for what counts. Now Maxim 10 states Nemo debet bis vexeri pro idem causa, meaning no one should be vexed twice for the same cause. The principle behind the Fifth Amendment's double jeopardy clause, a person can't be tried twice for the same offense after acquittal, conviction, or in some cases mistrial. The best illustration of this is Blockberger versus United States. The Supreme Court created the same elements test. 2 offenses are in the same offense for double jeopardy purposes if each one requires proof of an additional element the other doesn't. Here's an exam trick to remember it. The Blockberger test, if each crime needs one extra element the other lacks, they are different offenses. No double jeopardy bar. Maxim 11 is Doli Incapax, meaning incapable of committing a crime. Very young people are treated as lacking the capacity to form true criminal intent, and courts recognize that juveniles are generally less culpable than adults. The best illustration of this is Roper versus Simmons. The Supreme Court held the death penalty unconstitutional for crimes committed by offenders under 18. Reasoning that juveniles have diminished culpability due to immaturity and underdeveloped judgment. And here's an exam trick to remember it. Kids aren't held to be adult standard. Roper versus Simmons is the court formally recognized reduced culpability of juveniles. Now coming on to Maxim 12, that is Nemo dat quod non habet, meaning no one can give what they do not have. No one can give what they do not have. A seller generally can't transfer better title to goods than they themselves actually hold. You can't pass on ownership you never had. The best illustration of this is statutory doctrine. The UCC carves out a major exception. A merchant who was entrusted with goods can pass good title to a good faith buyer in the ordinary course of business, even though the entruster still technically owes them. Here's an exam trick to remember it. Can't sell what you don't own. But watch for the UCC's entrustment exception protecting good faith buyers from merchants. Maxim 13 states de minimis non curat lex, meaning the law does not concern itself with trifles. Courts won't get involved in disputes over genuinely trivial harm or technical violations that cause no meaningful damage. The law saves its attention for real disputes. The best illustration of this is widely applied doctrine, federal and states courts, and general application. Courts across contract, tort, and criminal law routinely invoke this principle to dismiss claims where the alleged harm, a few seconds of delay, a negligible overcharge, minor contact is too small to warrant judicial relief. And here's an exam trick to remember it. Tiny, trivial harm equals no case. Courts aren't in the business of policing trifles. Now, Maxim 14 is in pari delicto, meaning in equal fault, a doctrine that can bar a plaintiff who was equally at fault in the wrongdoing from recovering damages connected to that same wrongdoing. The best illustration of this is Bateman-Eichler, Hill-Richards versus Berner. The Supreme Court held that in pari delicto defense only bars a securities fraud claim where the plaintiff bears at least substantially equal responsibility for the violation. It's not automatic. And here's your exam trick to remember it. Both sides equally guilty. Courts may leave you exactly where they find you, but Bateman-Eichler shows the fault has to be truly comparable. Maxim 15 is ignorantia juris non excusat, meaning ignorance of law is no excuse. Everyone is presumed to know the law, so I didn't know that was illegal generally isn't a valid defense to criminal or civil liability. The best illustration of this is Cheek versus United States. A pilot who genuinely, if unreasonably, believed wages weren't taxable income was charged with willful tax evasion. The Supreme Court held a true good faith misunderstanding of complex tax law can negate the willfulness element, a narrow, notable exception. And here's the exam trick to remember it. General rule. Not knowing the law is no defense. But Cheek carved out a narrow exception for genuine good faith misunderstanding in complex tax law. Now, Maxim 16 is consensus ad idem, meaning meeting of the minds. A valid contract requires both parties to actually agree on the same essential terms. If each party is thinking of a fundamentally different thing, there is no true agreement and no enforceable contract. The best illustration of this is Raffles versus House. Two ships were both named as Peerless, and buyer and seller each meant a different ship sailing at a different time. The court held that there was no true meeting of the minds. The contract was void for mutual mistake, and here's your example to remember it. Both sides have to be agreeing to the same thing. Two peerless ships, two different deals, no contract. Now, Maxim 17 is Contra Proferentem, meaning against the one who offers. When a contract term is genuinely ambiguous, courts construe it against the party who drafted it. The drafter had the power to write it clearly and didn't. The best illustration of this is statutory doctrine restatement. This rule shows up constantly with standard form and insurance contracts, where one side has all the drafting power. Courts use it to prevent drafters from hiding behind their own sloppy or self-serving language. And here's an example to remember it. Wrote the ambiguous clause yourself? Courts read it against you, not the other side. Now, Maxim 18 is Novus Actus Interveniens, meaning a new intervening act. An unforeseeable intervening event can break the chain of legal causation, cutting off the original defendant's liability for what happens afterward. The best illustration of this is Watson versus Kentucky and Indiana Bridge and R.R. Company. A railroad negligently spilled gasoline. Someone later deliberately lit a match and caused an explosion. The court held that if the second act was a deliberate, unforeseeable criminal act, it should be a superseding cause breaking the chain of liability. And here's an example to remember it. original negligence plus a truly unforeseeable new act is equals to the new act can cut off liability for what comes after. Now maxim 18 is Keetam, meaning he who sues for the king as for himself. A Keetam action lets a private citizen or relator sue on behalf of the government for fraud against it, most commonly under the Federal False Claims Act, and keep a share of any recovery. The best illustration of this is Vermont Agency of Natural Resources versus US ex rel Stevens. The Supreme Court held that a Keetam relator has Article 3 standing to sue because the government's injury is effectively assigned to the relator by statute, a uniquely American procedural device. And here's your exam trick to remember it. Keetam means a private citizen suing for the government and getting paid a cut if they win. Now coming on to the last maxim, that is Ignorantia Facti Excusat, meaning ignorance of fact excuses. Unlike ignorance of the law, a genuine and reasonable mistake about the facts of a situation can excuse criminal liability because it can negate the mental state the crime requires. The best illustration of this is statutory doctrine, Model Penal Code. If someone honestly and reasonably believes an item is theirs when taking it, a genuine mistake of fact can negate the intent required for theft. Very different from simply not knowing a law exists. And here's your exam trick to remember it. Wrong about the law, no excuse. Genuinely wrong about the facts can be a real defense. And that's a wrap. So if you found this lesson helpful, be sure to comment with the legal maxim you find hardest to remember. Thanks for watching it, and I'll see you in the next lesson.